On June 5th, 2023, the U.S. Supreme Court announced it was going to hear another trademark case. The USPTO denied registration for Trump Too Small because it applied to a real person without the written consent. The Federal Circuit held when applied to a public figure, this violates the First Amendment. The Supreme Court has agreed to hear that case. But now, for the reason you tuned into this video. The Supreme Court decided a case involving a dog toy that replaced Jack Daniel's trade dress with poop jokes. There's been a lot of discussion about this case already, but what does it mean in layman's terms? Personally, I was hoping for a broad decision granting free speech rights to parodies. In fact, during oral argument, there was a lot of discussion about free speech.
Did you agree with the suggestion that the First Amendment does not protect speech that is misleading?
Well,
we wouldn't have very much speech in this country if that were the case.
Justice Kagan, however, who became the author of the opinion, said she didn't get the joke.
The parody here, though, is not putting Jack Daniels on a dog toy. There is far more to it. And there is, in this case...
What is there to it? What is the parody here?
The parody?
Yeah.
The parody is...
Because maybe I just have no sense of humor, but... What's the parody?
The parody is multifold, but the testimony indicates, and it's not been disputed, that the parody is to make fun of marks that take themselves seriously.
Well, I mean, you say that, but you make fun of a lot of marks. Doggy Walker, Dos Perros, Smella Arpa, Canine Cola, Mountain Drool. Are all of these companies taking themselves too seriously?
And then again, later, she says,
whether there should be a better test to think about First Amendment issues. You're sort of out of that. I think you're sort of leagues away from that. This is a standard commercial product. This is not a political T-shirt. It's not a film. It's not an artistic photograph. It's nothing of those things. It's a standard commercial product. I don't see the parody, but, whatever.
The Supreme Court very narrowly held that when an alleged infringer uses a trademark as a source identifier of their own goods, courts must apply the likelihood of confusion test, even if there is an artistic relevance to the use of the mark. What does that mean? Trademarks identify the source of goods and services. When a brand name is used in a context not meant to be a source identifier, such as in a movie, for example, it is not being used as a trademark.
Don't be ridiculous. You're sitting here. Careful, that's a Louis. That is a Louis Vuitton.
The court held that just because a mark has a humorous message does not mean it automatically gets to skip the likelihood of a confusion test. One reason the decision was so narrow was that, according to the court, VIP Products conceded that it used Bad Spaniels as a source identifier. The court pointed to the hang tag that showed the Bad Spaniels mark right next to its Silly Squeakers mark. VIP Products sells quite a few dog toys under the Silly Squeakers umbrella. To name a few, Canine Cola, Mr. Slobber, Smella Arpaw, and Doggy Walker. The procedural effect of this decision is that it will go back to the trial court on the issue of likelihood of confusion. It's still possible VIP Products may ultimately win on that issue. Although I was disappointed with the scope of the decision, it was not incorrect on the law. Barry's favorite dog toy company, BarkBox, has a ton of great parody toys, but in my opinion, they don't use the names as trademarks. So for example here, the Chihuahua Spicy Hot Sauce. So Barry's favorite toys, BarkBox toys, should be safe for now as long as they're not using these parodies as trademarks. So as Barry knows, trademarks are fun.